So what is happening here this afternoon? This afternoon, we're sponsoring a panel discussion, that is the Grenada Bar Association, and the topic is, how would the abolition of flogging in the law, the decriminalisation of marijuana, and the rehabilitation of offenders impact Grenada's juvenile and criminal justice systems and the wider society? First up, we would have, and we pause to recognize the presence of His Lordship, the Bishop of Grenada, and who has very early sent to indicate, we invite you up to the very front, Our Lordship. And he is someone who has done a lot of work in his ministry, working with juveniles and persons in conflict with the law, in many regards. But I'm sure that he will offer a few words this afternoon if he so wishes. But just sharing, Your Lordship, that we're being live streamed on the World Wide Web. So going on, sorry, and I continue, that we are discussing and sharing and conversing, because this is not going to be a one-way discussion. We expect a lot of interaction. We're discussing about the abolition of flogging in the law, the decriminalisation of marijuana, and the rehabilitation of offenders, and how this would impact Grenada's juvenile and criminal justice systems and the wider society. So I begin very, very briefly as chairman to share with you that for us in the Bar Association, we have been doing our best, especially during Law Week, to reach out to citizens, sharing, and today, even now, some of our members are doing pro bono work. That is giving free legal advice in collaboration with the Legal Aid and Counseling Clinic, and as we speak, some lawyers are meeting with members of the public. It is important that we emphasize that for us, and I share with you very briefly a quotation from Martin Luther King when he said, "We need leaders, not in love with money, but in love with justice, not in love with publicity, but with humanity." So, speaking on behalf of the bar, this is exactly what guides us when we hold our Law Week. We go to the prisons. One of our bar executive members, Mr. Joshua John, who will be speaking with us very shortly, he has come directly from Her Majesty's prisons, where not only do we make donations, but we also counsel some of the persons who are there. This week as well, we are donating to the Kidney Foundation, and at the end of it all, after this panel discussion and after the moot tomorrow, and we see and recognize the TAM-CC students who are here, especially the law students, the second-year law students, and even as we speak, some of their peers are preparing diligently for the moot tomorrow at 3 o'clock, and they'll be facing a rail judge in a rail courtroom at the High Court number 2. So for us, as I said, we are discussing some very difficult, perhaps different topics. We're not talking about how we make money. We're not talking about taxes. We're talking about good governance of Grenada. We're talking about the future. We are talking about whether flogging, which has come down from slavery as punishment for slaves and is now so accepted and justified, sometimes in our homes, in the law, in the legal system, whether we think that this is not in itself perpetuating violence. As we see so many of our young people coming into conflict with the law because of what some of us here, right here in our own society, as well as throughout the Caribbean, originating from Jamaica, believe, that marijuana is a sacred herb. We are seeing marijuana being legalized in some of our own South American countries and in some American states. Is this something that we want to do here in Grenada so that perhaps we do not criminalize our young men and our young women who come into conflict with the law for having a spliff? These are real issues that we are going to discuss this afternoon. Is decriminalization okay, but legalization carrying it too far? For me, I recall growing up hearing all of those Bob Marley songs, singing the one draw, pass the duchy on the left-hand side, and so on and so on. And at the time, of course, I remember I was a little goody two-shoes church girl, so I wasn't thinking so much about the lyrics, but I was bouncing and dancing and skanking to the beat like everyone else. But now this has come home as part of the Caribbean culture. So how can we then criminalize our children when it would be we who have shared this culture with them? These are some of the issues that we want to discuss. We also want to discuss when persons who perhaps in earlier days would have had a little spliff and they would have been jailed for this, how are they to be rehabilitated? Are we to criminalize them, treat them forever as criminals, refuse to allow them to re-enter into society, or perhaps misguided, they damaged property, or perhaps committed other acts that would in fact by law be criminal? Does this mean that they are doomed forever not to be accepted and embraced by us, even in their own families? These are some of the hard questions and topics that we are discussing this afternoon. But without further ado, I invite to the podium Ms. Jacqueline Lourise Pascal, and many of you would know her because she has been unceasingly and unflaggedly a member of the Grenada National Organization for Women and the Grenada National Coalition on the Rights of the Child, and is an executive member, the project coordinator for GNOW, and presently she has offered to serve in a national committee for the prevention of child sexual abuse as its coordinator, and she is coming to set the tone based on being out there in the fields, the trenches, working with victims, especially of gender-based violence and of violence. So without further ado, I invite her to come up very briefly as she sets the tone for this afternoon's panel discussion. Jacqueline Lourise, I call her Lourise.
Thank you. Okay. Members of the head table, Senator Honorable Peter David, His Lordship, other members of the clergy, the Bar Association members, and other lawyers, students from TAMCC, the media, thank you for this opportunity, Lady Joseph. I'm only going to stick to abolishing flogging, that side of it. And nothing concrete, just some thoughts. So when Anande starts speaking about slavery, so I said, oh, she's taking my line, because that's the first thing I'm going to discuss. So when abolitionists wanted to convey a sense of slavery's horror, they told stories about women. They emphasized the violation of women's bodies that accompanied enslavement, the sexual brutality, the vicious flogging, the enforced nakedness. During the pre-emancipation period, so that's 1830s around there, there's a sister called Catherine Williams, a slave on a Jamaican plantation. She refused to become the mistress of the overseer, and this resulted in her being severely flogged. Quote, despite her back being reduced to a mass of blood, Williams continued to resist the overseer's sexual demands. She preferred imprisonment to the surrender of her honor. Clearly, flogging her as a punishment had no impact on the sister. It did not change her trajectory to maintaining and keeping her honor. We are told we must not spare the rod and spoil the child. Proverbs 13:24. It is the custom to interpret the verse in its literal sense. So I grew up with flogging. I get plenty licks. And I'm told, look at your come out. You come out good. I don't know. I don't know the implication of that. I haven't done the research on me, but sometimes I wonder about the many licks I got. So the jury is out. So I believe that there's a perpetuation of violence, male on male violence, male on female violence, female on male violence, and children violence against on each other. So where's that coming from? What is the genesis of that? That needs to be interrogated. But what is the rod? What does it look like? A rod is used to guide and not to beat. We quote and we know Psalm 23 by heart, but the verse I like the best, verse 4, says, "Thy rod and thy staff, they comfort me." I am inviting you to do some reflection on those two verses. Corporal punishment and the treaty bodies. There's a legal framework. So we had two acts. The Education Act, which we still maintain corporal punishment in that act, and you have the 2014, the Juvenile Justice Act, where there's no corporal punishment mentioned in there. Now, the Convention on the Rights of the Child, which Grenada signed and ratified in 1990, in one of the concluding observations of that committee, which is based in Geneva, they expressed concern that corporal punishment remains lawful in the home, that authorized persons in schools are permitted to administer corporal punishment as a disciplinary measure, and that corporal punishment is a sentencing option in the judicial system. So I leave that to the juries and to the panel there. They'll discuss all of that. I'm just making some comments. Now, there are some recommendations provided by the CRC and the Human Rights Review, the Periodic Review Report, which the GNCRC and GINA, who I'm representing here, endorse. Now, the committee recommends that the state party explicitly prohibit by law all forms of violence against children, and they're looking at corporal punishment as violence, including corporal punishment in all settings, including the family, schools, alternative childcare, and places of detention for children, and implement those laws effectively. And also in the recommendation, the state party intensify its awareness-raising campaigns in order to change perceptions regarding corporal punishment and promote alternative forms of discipline in a manner consistent with the child's human dignity and in accordance with the convention, especially Article 28, Paragraph 2. That will be the Convention on the Rights of the Child article. Now, in 2015, Human Rights Periodic Review says they recommended that Grenada pass and implement laws banning corporal punishment and should take effective measures to prohibit the use of corporal punishment to minors in schools and eliminate corporal punishment to children both in the public and private life. I don't know if there's any law that prohibits corporal punishment in the private life. The lawyers will have to tell us that. I don't know, but I don't think so. Now, in the current, this is a 2017, the CRC committee report, where the authors were able to write to the committee answering the questions, this concern, we were able to see that there are now child-friendly schools where conscious discipline is being promoted as an alternative to corporal punishment. Now, the conscious discipline program is done by Windref at the St. George's University, and is also promoted and supported by UNICEF, United Nations, that entity for children. And that has been started about 4 years ago. Now, the program consists of training in conscious discipline in 16 schools in Grenada. So now that is being evaluated. Now, clearly, these are positive steps towards the abolition of flogging in the state system, and to the most vulnerable in our society, and more importantly, the ones whom we are mandated to protect. I thank you.
Let us just give Sister Larice Pascal another round of applause as she's setting the tone for our discussions on one of the aspects of our panel this afternoon. We'll be moving right along as we invite Attorney at Law Joshua John, one of our younger attorneys, but very much able and involved, especially in defending children who have come into conflict with the law, and he'll be coming to speak to this topic. Let's give him a round of applause. Just reminding we are on live stream. We'll be live stream.
Good afternoon, all. All you wake up, all you need some coffee, and find out hearing any good responses. I know it's the afternoon. So I'm here to speak about the abolition of flogging. The abolition of flogging in the law and and its impacts on violence in children and adults in society, leading to violence. So before I go into flogging, I will just speak some things about myself. I am a legal practitioner. I practice mostly civil law, but I do some criminal matters as well. And that brings me to juvenile justice. What made me do that area is really that I saw that there was a need for representation of the juveniles. In fact, I came across so much work in that I felt overwhelmed at times before the magistrate's court. So this is a very interesting topic for me to speak on, and I will just go in without further ado. Historically, slavery, as Lady Joseph mentioned, flogging, as Lady Joseph mentioned, came down from slavery. Yeah? In terms of its effect on slaves, it would have been to demoralize the slave's character, and really to humiliate them in terms of their spirits. If I was to go into this from a legal point of view, Section 275 of the Criminal Code speaks to flogging and whipping. And it says, in relation to juveniles, a juvenile offender shall not be sentenced to flogging. In lieu thereof, he may be sentenced to be whipped. No offense of flogging or whipping shall be passed upon a female of any age, but in lieu of such sentence, the court may sentence a female to solitary confinement. Flogging shall be with a cat of a pattern approved by the Governor General, and a sentence of flogging shall specify the number of strokes, which shall not exceed 12. So you can see basically that the state legalizes or sanctions flogging or whipping, yeah, against its citizens. But more in particular, males, as you can see the disparity amongst the gender. Generally speaking, most of the juveniles that come before the courts are male. I have never been at the court where a sentence was passed to a juvenile for whipping. I have not experienced that. I've never come across that since I've been practicing. In terms of the human aspects or human rights aspects of this, what can I say about that? It is really a form of humiliation to be subject to whipping and flogging, especially at the arms of the law. In terms of the arbitrary nature of it, there is no set guidelines as to how the sentence must be carried out in terms of the harshness of it. The law only speaks to how much strokes must be involved, but we know one can beat someone in terms of flogging physically, and that may be light in nature, and another person whose hand is what we call heavy, it will be another issue. So really and truly, there's an arbitrary nature in terms of the sentencing aspect of flogging. In terms of it being a reasonable punishment, I don't see how flogging and any form of whipping as a punishment is going to deter people or juveniles or adults in general from committing crimes. So I don't see the general correlation between flogging as a punishment as it relates to the deterrence of crime and justice, criminal justice on the wider society. What I can say, however, is that from a legal perspective, I do find that the very nature of flogging to be a form of corporal punishment, legislated corporal punishment. And I find the law has really no right to be administering flogging as a punishment. And as I go straight into some case law to give you some legal perspective from one of my colleagues, Sheba Augustine. In the case of Pinder and the Queen, a 2002 Privy Council decision out of the jurisdiction of the Bahamas, 5 out of the 5 judges that heard the case agreed that judicial corporal punishment in the form of flogging amounted to cruel, inhumane, and degrading treatment or punishment. They acknowledged that the Constitution guards against the type of punishment. However, 3 of the 5 judges went on to hold and thereby decide that matter that it was not unconstitutional, despite its violation of the right to the subject to the right, to not to be subject to torture, inhuman and degrading punishment or treatment. So this begs the question, as myself as a practitioner, whether this is a violation of our constitutional rights as citizens of Grenada. In our Constitution, Section 5, subsection 2, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section, to the extent that the law in question authorizes the infliction of any description of punishment that was lawful in Grenada immediately before the coming into operation of the Constitution. What that says in a nutshell is that whatever punishment that was there before shall not be inconsistent with what that is being authorized now. So as I read before, Section 75 of our criminal code legalizes or sanctions or governs flogging and whipping. And since we have what's the word I'm trying to say? We as citizens have a right to be free, or the right to not to be subject to cruel and inhumane degrading punishment. We may have some recourse, I may argue, against the repeal of this law. Although generally this same section under the law saves all punishment that was enacted before the coming into of the Constitution. But I think if we seek maybe to challenge this may be we may have some grounds as to proceed in that area, because our Constitution is the supreme law of the land. In conclusion, really, I would just want to summarize the cons, really, of flogging and whipping on society. As I said, the humiliation of citizens. I don't know if you remember the Paul Chetram case that was before our courts in relation to the flogging of this gentleman who was sentenced for disorderly conduct or behavior before Magistrate Seals. And it is being alleged that he was severely beaten at the hands of our lawmen. So one can imagine the type of effect that would have on a person, especially an adult. Yeah? I know we will probably say we're too big for licks and we're too big for flogging, but it's still sanctioned under our law. So you can see an 80-year-old having contravened the law being subject to flogging, yeah? And how we as a society may look at the severity or the impact of that punishment on that particular person, yeah? Yes. And as I said before, the arbitrary nature of the flogging, in that there is no really guideline as to how the flogging should be administered, other than the number of strokes that should be administered. And that generally, in closing, lastly, that violence generally doesn't really deter violence, in my estimation of the impact that it would have on a person. Yeah? So that's it for my presentation. I know I may have been a bit all over the place, but I was just given the topic to speak on today, so I didn't have much time to prepare and research, as I could have given you a bit more of my perspective. Yeah? But it's a discussion, and as we're here to discuss flogging as it affects all of us. Again, thank you.
Thank you very much, Joshua. And indeed, just to say that he replaces on the panel Mr. Jerry Edwin, who was unable to come because he's unwell. We're moving right along, and we invite Miss Melisse Ogilvie, and as I said, she is the team leader at the Bacolet Juvenile Detention Center. So she is doing the hands-on work and seeing everything coming home to roost, for want of a better phrase, before her eyes and before given the work that herself and team would be doing there. So I will let her speak a little bit more about what is happening, what they're doing, and what strides they're making, and the impacts that happen in the society that would be realized in that center. Miss Ogilvie, please give her a round of applause.
Thank you, Lady Anande Trotman-Joseph. Pleasant good afternoon to all, fellow members of the panel, media, and persons representing the Bar Association here, and those of you who are just part of the audience. I manage the Grand Bacolet Juvenile Rehabilitation and Treatment Center. The facility was built with the support of the OECS USAID Juvenile Justice Reform Project, and it is a critical component in the national effort to reform and enhance the country's juvenile justice system. The aim of the juvenile justice system is really to prevent and divert potential offenders into positive living and to rehabilitate them, making them fruitful citizens. Facilitate a reduction in the offending behavior, see an overall improvement in their mental health, self-esteem, and of course to have no juvenile in prison. But before we go on, I think it's key for you to know some of the risk factors in juvenile offending. Now, a risk factor is anything that increases the probability of a person committing an offense. So when I look at the risk factors overall, because I will talk about a study done in Grenada, and the risk factors are quite similar. Risk factors for youth offending and substance abuse overlap. They have a lot to do with educational underachievement, young parenthood, adolescent mental health problems. So we're talking about poor parental supervision and discipline, conflict within the home and in the community, a history of criminal activity, parental attitudes that condone antisocial and criminal behavior, low income, poor housing, and we know these things, right? Low achievement beginning in primary school, so we miss those children from the primary school. Aggressive behavior, including bullying. Lack of commitment, including truancy, and that could have something to do with the family's functioning. So if you're in a dysfunctional family environment, that will impact that. School disorganization, so of course, within the school system, if there are no support mechanisms for you to first identify you as a child at risk, you won't be adequately supported. Living in a disadvantaged neighborhoods, of course, we know that there are some neighborhoods where there are more, there's a higher rate of criminal activity. Neglect, availability of drugs, lack of neighborhood attachment. Now, we're talking about the personal, those things for the child themselves. So it could be identified from early childhood, right? Hyperactivity and impulsivity. And we say, oh, the child just bad behave. Low intelligence and cognitive impairment, we see that a lot at Bacolet. Alienation and lack of social commitment. Attitudes that condone offending and drug misuse. So it's done. I live in Dabo. Everybody's smoking a spliff. Why not? Early involvement in crime and drug use. Friendships with peers involved in crime and drug use. Now, when we turn to Grenada, a study done by Dr. Wendy Crawford Daniel, as I said, it's quite similar, but I'm going to list. For Grenada, it says poor parenting, no family support, poor quality of family support, poor parenting skills. And I just want to pause there for a minute because it reminds me, I kind of intruded on a session taking place at the center, and the instructions the counselor gave to the juveniles were to, face each other and talk about your day and some of the things, or your week, and some of the things that you wish you can change and so. And so I joined these two boys, And I said to them, well, this is how I feel. I'm really worried about you. Because I feel like if we're not reaching you, and what is it that we can do different? And one said to me, he said, Miss, y'all need to speak to the parents so that they can treat us how we're supposed to be treated. And that is very profound, right? Where, some parents, and for that young man, I have to say, we're seeing the most improvement in him because he has that insight. And then there's a supportive, on the surface, it appears that this parent is very supportive, always there, attending meetings and so forth, there at court. But really and truly, in discussion with the parent, of course, there was some neglect. And she had to, and it's not intentional neglect, but it's because she's a single parent, right? So she had to go out to work, and the child, of course, is home alone, unsupervised. And we go on to poor guidance at home and at the community level, erosion of the family system in the value system in the family, lack of supervision, and that is key. So, of course, too much opportunity for children to get into trouble. The poor family structure, strong attachment to peers because of the inadequate structure in the home. And then we say, sometimes the children are very much attached to their peers because they don't have any real attachment to their family members. Everybody exists in the family home, and the relationship is superficial. You provide the basic needs, so everybody go about their business. There's no connection. Community culture, drugs and other substance abuse, alcohol and marijuana. Exposure to abuse, but both sexual and physical, and I'm going to touch about that and the impact on the juvenile. Gang culture in schools. Lack of sustainable systems to help children who are from impoverished families. Violence in the family, so domestic violence and other abuse. High teenage pregnancy leading to poor parenting skills. Abandonment and neglect, of course, that's abuse. The cycle of challenging parenting, seeing intergenerational situations of difficulty with parenting. So we do have residents who they have family members who've been through the system as well. And they have siblings, actually, who are also in the system. Individual attributes, this is for Grenada, okay? Individual attributes such as bullying behavior, stealing of the student's school property, exhibiting inappropriate social behavior towards others. 2 more minutes? Oh, I wasn't aware. Sorry. You didn't have to give me, because I really want to talk about the mental health. Thank you. Now, many of our juveniles have experienced some kind of trauma, right? And I have worked in Child Protection Authority, and I'm seeing some of the cases that I knew from Child Protection Authority, and I've seen them at Bacolet, right? And this impacts on the overall mental health and the outcome for our juveniles. Those adverse childhood experiences, so it's whether they've been abused, neglect, or any kind of violence that they've experienced, could cause affective disorders, major depression, and we see that. And a lot of residents are self-medicating with marijuana. Yes? And of course, then they have substance-induced psychosis. We have persistent depression, psychotic disorders, separation anxiety, attachment disorders. So that's why they steal. They're unable to attach to anyone, consider anyone's feelings. Disruptive behaviors, conduct, and substance use disorders. And of course, attention deficit hyperactivity disorder. I want to touch on conduct because several of them also have conduct disorders, right, which is brought on by their early childhood experience, childhood experiences. Some of them are suffering with post-traumatic stress disorder, right? So when you, and for adolescents, it comes out differently. It comes out in aggression. Yes, you may see signs of depression, but risk-taking behaviors is a sign of post-traumatic stress disorder because they have experienced something in their early childhood. So a conduct disorder, the symptoms are behavioral and emotional problems, right? And you see them and we label them as bad and delinquent. And the signs are, and sometimes the signs appear before they're age 10. And so you see some children in primary school and they're misbehaving, and they're just bad and the parent need to beat them and you're beating them and you find it making any difference, okay? So it's aggressive conduct, deceitful behavior, destructive behavior, violation of rules, that's why there's an offense, intimidation, bullying of others, physically harming people or animals on purpose, committing rape, use of weapon. Deceitful behavior may include lying, breaking and entering, stealing, forgery. And of course, we start with skipping school, running away from home. All those are conduct disorders, right? Running away from home, drug and alcohol use, sexual behavior at a very young age. So I think in looking at the juvenile justice system, I think first the approach should be early intervention and an integrated approach to juvenile justice, to child care, to child protection, because in an integrated approach, the child at risk is identified from an early age, from your early childhood learning centers, from your primary schools, and then there are systems in place to work and support the family throughout. As I said, many of our juveniles they have come through the system. Many of them are underachievers. They drop out in Form 3, but when you realize they're not supposed to be in secondary school in the first place. So if there was special support and so at the primary school level, then maybe we could have prevented them being involved in the juvenile justice system. Thank you.
Thank you very much, Melisse. But as we reflect a little bit on what we heard from Melisse, it tells us that as citizens, as parents, as siblings, as aunts, uncles, we have to look for the signs in our young people especially, because it's easier to fix a problem of a young person than to fix it when they're up in Her Majesty's prison having committed a more serious offense. And what it is telling us as well is that we are really, really perhaps not paying enough attention, enough focus to psychosocial support, to counseling, to understanding, lack of parenting, lack of support for our young people. And they're looking for family, they're looking for friends, and they can be easily misled when we do not pay the kind of attention that we should, not only in the home, but in the school, the church, and in the wider community and society. But going on, we know that there are other panelists, so I invite now to the podium Mr. Richie Maitland, who is himself a human rights expert and would have touched a lot of this on the academic side, but as an attorney at law going back into the courtroom, going back into the magistrate's court, he's also very much hands-on about some of these problems. He himself is a young graduate of PBC, I know. He himself would understand the culture, and also he would share his own experiences, not only with us today, but with the young people that he would provide legal counsel for and generally wider counsel. Without further ado, Richie Maitland.
Thank you very much, Lady Trotman-Joseph. So Jason is a 17-year-old boy from River Road in his first year of TAMCC. He's doing social sciences and wants to study law. His mother, Miss B, works as a cleaner in one of the hotels in Grenada and is proud of her son, whom she struggled to raise as a single mother. One night he is liming with friends after a football match. They are all from River Road and they all grew up together, though most of the others didn't complete secondary school or didn't pursue higher education, having performed poorly at CXC. They are sharing a joint and telling jokes on one another, as is their custom after their football matches. While Jason has the joint, an unmarked vehicle screeches to a halt near them. 4 police officers jump out of the vehicle and order them all to lay face down. They are all searched. Jason is found with a joint and is arrested and incarcerated and charged for possession of a controlled substance, to wit, a partly burnt marijuana cigarette. Having been convicted, he is sentenced to flog. The whip is made by wounding together several strands of a tamarind branch. He is stripped naked, blindfolded, and strapped to an instrument like a table, which is referred to as a horse, and then beaten like an animal. He pees, he bawls, he faints, he gets a record. He's also suspended from TAMCC and then expelled pursuant to their student handbook. Just like that, his and his mother's dreams of education, lifting them out of poverty from one generation to the next, is dashed. More likely than not, he would never be able to get a visa. He would never be able to work in a public service. He would never be able to work in many of the private sector jobs which now require police certificates, and he would never be able to pursue higher education. Those of us who have worked in criminal defense have encountered many Jasons. Some of us have children, in fact, who are like Jason, save and except that they may be insulated by privilege. They live in areas where police are unlikely to do ambush raids. The saying goes, when you are poor, you're exposed. Now, these stories remind us that human rights are about the humans. And a conversation on human rights is always a question about what kind of society we want to build for ourselves. Human rights is about a society's self-reflection. What kind of access and opportunity do we wish to create for youth? How do we treat with addiction, experimentation, and drug use? How do we treat with genuine incidences of wrongdoing? Do we jail and attempt to rehabilitate offenders, as is a general global standard? Do we chop off hands, as happens in Iran? Do we tie people to horses and whip them, as happens in Grenada? As a matter of fact, do we pack them like sardines in a poorly ventilated cell with no mattress and a mess bucket, as also happens in Grenada? Perhaps the most understated human rights issue in Grenada is the issue of how prisoners are in fact treated, and I would love, in fact, to see more advocacy being done around that issue. The Commonwealth last year in 2016 published a Youth Development Index. Grenada is, in fact, according to that index, in the top 5 countries with a youth bulge. So if you're looking at a population gap, then the portion of that, the representation that reflects youth that is between 15 to 29 bulges out. So we have a very huge youth population relative to the rest of our demographic in the population. And as we all know, youth are particularly vulnerable. Now, in that Youth Development Index, Grenada scored 0.47. So the figure 1 represents a perfect score, that youth are hitting all the indices of development, and Grenada ranked, in fact, slightly below the midway point. There were some areas where we ranked pretty high in, areas, for instance, such as education. Grenada scored 0.75. And in other areas, we scored extremely low in. So for instance, in the area of employment, we scored 0.011. The aim of that Youth Development Index was to assess the extent to which countries provide effective preconditions for youth development, whereby policies are framed as part of a process of enlarging people's choices and providing the freedoms essential to fulfill those capabilities and choices. In that framework, they also regard poverty not simply as income deprivation, not only as deprivation of income, but as deprivation of capability. So going back to Jason and his situation, have we enlarged his choices, or have we deprived him of capability? That's a question we must always ask ourselves. it is very easy to continue enforcing outdated paradigms of legislative intervention which don't serve us anymore. And I think it's time that we start to really look at that critically as lawyers, as persons in the general wider society. Flogging today only happens in 33 countries in the whole world. Those countries are all either former British territories or Islamic countries. So flogging, like many other aspects of our laws, or a legislative inheritance from our former British colonizers. They have since abandoned the practice of flogging since 1948, so approximately 70 years now. We have still kept it. The Privy Council, Grenada's highest court of appeal, in the judgment in Pinda, which was referred to, has said, they have ruled that flogging is in fact cruel and inhumane and degrading punishment or treatment. The only reason that flogging can still happen under our laws is because of this very quaint provision that our Constitution has called a savings law provision, which essentially says that all forms of punishment that would have existed prior to coming into effect of the Constitution remain, or basically immunized from challenge. So in other words, if bashing somebody's head was an accepted punishment prior to coming into force of the Constitution, then nobody can challenge that constitutionally. And that's something I would like to see some of our lawmakers take up, just the relevance really of the savings law provision. I know that we had an attempt at constitutional reform last year, which went headways. Let's see what the future holds for such prospects. Now, speaking about flogging and it being cruel and inhumane treatment, now, while it is that the Privy Council and many other courts, the Inter-American Human Rights Commission, have made these pronouncements, it is not the case that these are only, for instance, Western norms and foreign countries trying to impose. Jamaica abolished flogging in February 2013, and in fact, prior to that official abolition, the last sentence of flogging would have been carried out in 1997. And the government ministers who would have spoken publicly at the time have made it clear that Jamaica would have abolished flogging because they wanted to abide by the international human rights obligations. And when we speak about flogging, it's not only a conversation that's relevant to the courts and the justice system, it's also a conversation relevant to what happens in our home, what happens in our schools. Many persons have raised it before me, but it's really time we begin thinking as a society of the merit of beating people, of inflicting violence on people as a mode of punishing. I mean, if under the common law, parents do have that right, the law says that parents have a right to inflict corporal punishment, up to the point where it leaves a mark on children, but it is something we really need to interrogate, how effective it might be. Some people might say, well, I got licks and I turned out good, but it might be that you turned out good not because of the licks, but in spite of it, which is not something that people consider. A 2003 focus assessment done in Grenada, that's concerning marijuana decriminalization now, referred to many of the factors that persons would have pointed out as to why people use marijuana. Poor community support, poor parental support, poverty. I mean, if we really look into something that singly captures what the issue is. So here we have a situation where we have youth predisposed to marijuana use, predisposed to drug use generally. And instead of having a sort of harm reduction approach, which many countries are now adopting, we're choosing to criminalize and punish them, deny them of capabilities and opportunities in the past. In the future, sorry. To date, the past president, for instance, of the United Nations Human Rights Commission have called for decriminalization, for the removal of national laws that stigmatize and marginalize drug use, and have called for instead social intervention, so providing the sort of education in the schools that would give youth the information that they would need in order to avoid making bad choices, including using drugs, and other forms of social intervention that can address addiction and that sort of thing. I don't know, for instance, and as a matter of fact, it's not only that I don't know, the evidence is clear because Portugal has decriminalized since about 2001. So there's 14 years of research coming out of Portugal that shows that criminalization and strict prohibitionist approaches do not work, and that what works to address these issues is social intervention. There's more that I would like to say, but in keeping with my time constraints, I would stop here and perhaps I can take up some of the other issues in the question and answer.
Thank you very, very much, Richie. And we're moving right along. I know we're beginning to really think a lot about what is being said and the implications for all of us, really, and especially our young people. And we're happy to see so many students here this afternoon. So moving right along, we now invite Senator, the Honorable Peter David, who is also caretaker for the town of St. George and really interacting with a lot of Jasons, we understand, based on what we just heard from his colleague Richie. But more importantly, also recently, he has piloted in Parliament a bill to rehabilitate offenders, a bill of hope to give persons who would have records from the criminal courts a chance to live again, so that a Jason perhaps can have a future. So without further ado, I invite Senator David to come forward and make his panel presentation.
Thank you, Madam Chair. First of all, let me commend the Bar Association for having this activity. I wish we have many more of these so we can have some discussions about some of the serious issues facing us. I also want to commend the previous speakers for raising some very serious issues. I spend most of my day, in fact, all of my day really in criminal courts trying to represent people who need representation. Actually, one of the issues, though it's not down for discussion here this evening, is to develop a legal aid system that really provides legal assistance to people who cannot afford it. Because, you know, I always liken this to, you know, somebody going to a doctor. And I can't imagine a society where unless you have money, you can't get medical care. We have a system where unless you have money, you don't get legal aid unless you kill somebody. The only persons who are entitled to legal assistance from the state are those who commit murder and indicted to the High Court. And I think I witness it every day in our courts, ordinary people faced with issues like Richie just indicated, very minor issues, young people in schools. In fact, we have many of our kids now in schools coming into the court. And if they don't get legal assistance, they become exposed to criminal records. And quite frankly, some persons who are innocent are arrested. It happens all the time. Richie pointed out the group, the pickup of the group. There are many people within that group who may not have anything to do with that item, that the joint or whatever Richie spoke of. I'm simply saying that I'm not here to advocate that people need to be set free. I'm here to advocate that people need, just as I said to one person the other day, would you do an operation in a hospital without a doctor? Would you do surgery without a doctor? And the answer is obviously no. How do you appear in front of a judge with all of the technical issues in criminal courts and in courts in general without somebody by your side to at least help you through it? And in many cases, they will accept responsibility for their act, but they just need help. So I thought I'll just make a plug here, Madam Chair, for us to start thinking about how do we assist people faced with a criminal justice system that may be quite complicated for them. I also want to start to also say that on the issue of rehabilitation. First of all, let me say this, that Grenada has one of the lowest crime rates in the region. So I think while sometimes we become very alarmed, persons right around us, you know, I'm fascinated by the fact that we're surrounded by Trinidad, St. Vincent, St. Lucia, all of whom have very high crime rates, and we have a very low crime rate. I think it's something, in fact, I once spoke to somebody at the State Department, I think it was, and I said that we should conduct a study as to why we have such a low crime rate while our neighbors have such a high crime rate. I'm sure it's not simply because the slave ship dropped different kinds of slaves in Grenada. I don't think that would be an adequate explanation. But it's something we may need to study, because unless we study it and know why we have it, we may lose it. So it's something that we need to look at. Why does Grenada have this low crime rate while our immediate neighbors have such high crime rates? It's something we need to look at. So I just wanted to state that at the beginning of a couple of comments. I am here mostly to speak about rehabilitation of offenders. And I know there are persons who believe that we should never have rehabilitation. But Richie made an important point of the youngster. You know, every day I go to court, I meet young people. For example, you have a young man like in the example, what's his name, Richie? Jason. Richie is Jason. I noticed he said from River Road. My goodness. And we have people like that every day. They have First-time offenders, you're in school, and we all know that we all gave some trouble in school. And the other issue is this, that many of the issues that were resolved in our communities in the past are now being taken to court. So whereas in the past, if two boys had a fight, the mother and father would come together and resolve it, and they give the boy a little tap or something, or give them a hard talking. Today, you find many people coming to court for various reasons. One is the awareness of the laws. So somebody calls somebody a fool. I'm sure many people do not know that you can be charged for a crime of insulting language if you call someone a fool. Watch what you're saying. So because of that, we have many more people coming into the courts. Additionally, some people see the court as a way of getting compensated. And therefore, they bring people to court now for things that you do not normally do. So because of that, many more people are facing the possibility of criminal convictions. And these criminal convictions, according to the law as it was up to about 2 months ago, followed you for the rest of your life. It became very acute. To me, I became very aware of it when the Sandals project started, that the contractors now started to ask people for record of conviction. And I remember this young man coming to me with a record of conviction for obscene language and some disorderly conduct for about 20 years ago. And he asked me, how can I get a clean record so I can get a job? And my answer was, there is no way to get that done. 20, 30, 40 years, for the rest of your life, simple convictions follow you. You're going for a visa. I had one young man who got picked up for a joint many years ago. He had to go for his visa. What do we do? The fact is that we needed to find a way to clean people's records. The fact is that the judge grants a sentence to the magistrate. You do everything that you're supposed to do. You bonded or whatever. 10 years after, 15 years after, you're still not considered rehabilitated. So we decided, along with my very good friend, Sir Larry Joseph, to look into this. And with the assistance of many attorneys, we came up with legislation, the Rehabilitation of Offenders Act. And essentially what it says, and I don't want to go through it, I don't have much time. Essentially what it says is that after a particular period, your record can be cleaned. Now, there are some offenses that will never come off your record. For example, the offense of murder, voluntary manslaughter, rape, robbery with violence, arson, and any indictable offense carrying a penalty of over 15 years. So there are some crimes that will never come off your record. But other crimes like assault and other simpler crimes, your record can be cleaned after a period, and it depends. In some cases, it takes 4 years. In some cases, it takes 6 years. And in some cases, 10 years. For example, in a case where a fine or another non-custodial sentence was imposed, it takes 4 years. In a case where a sentence of imprisonment for a term not exceeding 6 months, it takes 6 years for your record to be cleaned. And in a case where a term of imprisonment exceeding 6 months but lower than 5 years, it will take you 10 years. But as I said, there are some, the murder, the manslaughter, the rape, robbery, violence, and arson, they never come off your record. The intention of this law is to give people a second chance. To give people a chance to conduct their lives, to get a job, to travel, to get visas, to do what their potential can allow them to do without the burden of a criminal conviction. Because the truth is, I mean, you saw a young man came in here just now and spoke to me. He came out of prison a couple of years ago. He did his time, and he's now gainfully employed. And he's really trying his best to keep on the right track. What do? Do we say to him, boy, you committed this crime 15 years ago, you have to have this record? And, the other thing is this, that you go to get a job. Grenada is a small place, so even if we do this sometimes, I have men come up to me and say, boy, Mr. David, I get a job, and a man pass and tell the employer, you're employing boy, he's a thief. Loses his job, and goes right back to doing what we don't want him to do. The point is, if we believe in rehabilitation, then we need to accept that people can change. There are many, many persons who I have had come to court when they were kids, committed offense when they were kids, and today you will be amazed. In fact, the truth is, many of us here, if years ago, it is how it is now, many of us would have been facing legal action because we gave a little trouble here, gave a little trouble there. The point is, we must accept that we as a society have a responsibility to try to help each other along. And rather being an uncaring society, where we believe that people who have committed crimes cannot change, we must in fact not only accept that they can, but put mechanisms in place to ensure that they have a clean record. Many people, I have seen many youngsters come from GBSS, PBC too. You know, while PBC may be an extremely good school, there are a couple of youngsters who may give trouble from PBC. And I've seen them come to court, and we have had to beg magistrates to not impose a criminal conviction on them so as to allow them to continue their studies and become very productive citizens. So my plea here tonight is twofold. One, to urge our society to develop and support a mechanism where more people, more lawyers, more attorneys financed by the state can help these young people in the courts. And secondly, to really ensure that the Rehabilitation of Offenders Act and all other forms of rehabilitation work well. I want to commend the persons at the Juvenile Center for doing an excellent job. Up until that center came into play, young people had to go to Her Majesty's prisons. It was a tragedy. Sometimes you go to the prisons and you see a young man in the middle of some old hardened persons, criminals, and you know what is taking place. They're training them to come out. I want to commend you, Madam Melisse Ogilvie, and your team at the Rehabilitation Center for doing an excellent job. I know there's much more to be done, but I want to commend your team for doing a good job. I think that is a clear indication that we are heading in the right direction. Thank you.
Let's give the goodly senator another round of applause, please. At this time, we've heard quite a lot as we try to grapple with some of the issues around what is happening in our society, what is happening in the justice system. And for us, we're thinking about the justice with a heart and justice with a hope. So to achieve that, by the time especially a young person comes to the court, well, it didn't begin there. We have to go all the way back into the society. But what will happen now at this stage is that we will take your questions and your comments, and if the viewers have any questions or comments for us, we will also take those and share them. So we are now going to open the floor for your questions and comments. There's a microphone here. You identify yourself and you say what you have to say. We see a first question, and I recognize Beverly Sinclair, who is a very senior Caribbean-wide journalist, and I'm going to let her have this mic. So I identified her before she could identify herself, but please come forward, Beverly, and share your comments and or questions to the panel.
Thank you very much, Lady Joseph. And questions, comments, observations. Miss Ogilvie first. I'm going to give all the questions that I have to all the panelists. So, Miss Ogilvie, you mentioned some mental illnesses that are identified among the young people at the center. I would like to know how were they analyzed, who did the analysis, and these diagnoses that have been made, are they definite? And what course of treatment is now in place for them? They could respond no.
Okay, I'll borrow that mic and you use that.
This one, okay, thanks.
Okay, thank you for your question. Now, at the moment, the center does not have any a psychologist, a clinical psychologist attached to us. We are working on that. but there are symptoms that are typical to certain disorders, right? So we wouldn't say that it's definite. They say they're presenting, appear to have a conduct disorder because based on this, that, the other. We do have a treatment team, and that it's the mandate to provide counseling to our residents and also non-residents. We do service non-residents. And it is hoped that in the coming future, the near future, that we would have a clinical psychologist on board to administer some assessment tools and give us some definite diagnosis. So learn it from the learning disabilities to the psychological disorders, but our residents are also seen by the psychiatric team at Mount Gay Hospital, and so there is some treatment element taking place there.
Well, I won't ask about the treatment, but I'm very curious about it, because in the absence of proper diagnoses, you know, I'm really curious about what type of treatments have been recommended for them and why. Because we're looking at punishment as a result of behaviors and intervening in the lives of these young people who are already in trouble.
Right.
You know, we don't want to make wrong intervention and do more harm than good.
Right. So what we do know, and I take the point, right? But what we do know that juvenile offenders, right, they have their similarities, okay? So their behaviors and their reasoning or for certain behaviors are similar, okay? So for example, those who have committed theft, right? It is a symptom of conduct disorder. Clear? Yes? Then if you have our treatment team, they're able to recognize depression, then there is counseling to suit that. When we also have sex offenders, right? And so the counseling will be geared towards that. Juvenile justice, just like Child Protection Authority, is a specialized area. And so at the moment, because we're new, so we are working towards being specialized to meet the needs of the juveniles. So it's what we have, and I have to say, it's not perfect, but we're doing a pretty darn good job at using the resources that we have available to us.
Okay. Senator David, as you have to leave shortly, and so do I must say, the bill that you have put forward recommending the expunging of these records, you broke it down into years according to the sentence imposed, but why not according to the crime committed? Because we have seen in the courts where sentences are not consistent.
Well, you know, the judges or magistrates impose a sentence depending on the seriousness they assess, because you can look at two cases. For example, you may have a grievous harm. A grievous harm can be, I take a knife and I break out. Grievous harm can be a bit more serious, and all of the circumstances around how it happened. So simply looking at the offenses, well, first of all, there are some offenses that you do not get rehabilitated from. Murder, manslaughter, rape, robbery with violence, and arson. Those are not included. But in the other cases, I suppose you're referring to in a case, for example, where a sentence of imprisonment for a term not exceeding 6 months. And if there's a sentence not exceeding 6 months, typically the magistrate or the judge would have looked at the circumstances, looked at the case, looked at the victim, looked at the accused and the convicted man, and made a determination that the level of seriousness should result in a sentence of 6 months. Now, in another case, the sentence of imprisonment between 6 months and 5 years, the judge or magistrate, in other words, we do not have fixed penalties that does not allow a magistrate or judge discretion. And the reason why discretion is a big thing in the law is because not all grievous harm cases are the same. Not all murder cases are the same. Not all manslaughter cases are the same. Not all, dangerous harm cases are the same. Depending on the circumstances in which it occurred, magistrates and judges have a discretion. Now, you may disagree with the magistrate or the judge. That's fine. But it is clear from all of the law that the discretion of the judge must not be hindered so that he or she can look at the circumstances. For example, you have a young man who has never committed a crime before, who has lived a perfectly lawful life for all his years. His sentence will be lower than somebody who has a history of convictions. So you look at that to determine when the rehabilitation would begin. And that is the reason for that.
I understand that. But the point I was making is a judge or a magistrate in handing down a sentence, say for grievous harm, may on any given day hand down sentences that appear to be so that where you can see so much discrepancy. We have public outcry about these sentences all the time. So regardless of the discretion and the limits of the law, the sentence which is actually handed down may not actually fit the crime.
In your opinion?
No. Not a matter of just opinion, a matter of comparison with other sentences that have been handed down for similar crimes.
Well, let me tell you that therefore, if a lawyer sees that a judge in same circumstances give this sentence and in other circumstances give a different sentence, and you look at it and see there is no valid reason for that, then that can go to the Court of Appeal. There's a Court of Appeal that can look at that to make a determination that the sentence needs to be changed. The point is that we live in a system where there's a justice system, and unless we have some level of confidence in it, we are all going to say, listen, I disagree with that judge, you know what, so I'm going to do this. I disagree with that law, so I'm going to do it. And we'll be no different from the people who are saying that they believe the law is bad, so they go break the law. The point is there is a mechanism provided by the same laws to allow for appeals in the event that you or anybody else, the lawyers for that matter, disagree. Hence, and that is why we have an orderly society.
Hence my question about that expunging of the record, because by nature of the way the sentences are handed down, a person may be denied or may have to wait longer to have their record expunged.
Well, that depends on the operation of the justice system that exists and the laws that exist. But, we do not have a perfect system. We have a system that we believe is the best system, and it says that at the end of the period of sentence, the rehabilitation begins, whatever the sentence imposed by the judge. I don't think there's any other way to do it.
There can be, but that's another discussion.
Well, recommendations will be welcome to the Parliament if you have some.
Well, I don't sit in Parliament, Senator.
No, recommendations to the Parliament,
okay.
Meaning your representative, wherever you live.
Okay. My final question is going to be to Mr. Joseph. In your discourse, John, not Joseph, John.
Yes.
Okay, sorry about that. Yes, you did mention at the end of your presentation that you were a bit all over the place. And
yes.
Yes, you were.
Yes.
But I got a little bit of confusion in my head in how you were defining punishment and discipline.
Okay.
So, because in my head, discipline happens long before punishment. And even sometimes when we're talking about flogging these days and beating and all the rest of it, we tend to talk about it as discipline.
Okay.
But that's not discipline.
No.
So I think I would just like for you, on the platform of what you were discussing, to clarify where discipline ends and where punishment begins.
Generally speaking, in terms of flogging is a punishment that is sanctioned by the law. Discipline, on another hand, is something that I would determine with something that is subjective. So what you may consider to be discipline in terms of whatever you're trying to correct in or instill in a particular person, it is different from punishment per se. Yeah, so punishment, it is therefore is something that would be what would act as a deterrent to something rather than discipline, which is something that you maybe try to implore upon somebody to correct something. I don't have a definition per se of discipline of my head that I can give you right now. But if you can just understand the difference that I'm trying to put forward.
So
yeah?
What I see, yes, I am wrapping up. You know, we need a lot of education then.
Yes,
with
we definitely
discipline
do.
And punishment.
We definitely do in terms of corporal punishment, as Richie was alluding to. There is the legislative aspect of it, and then there's the family aspect of it, and I guess sometimes it will overlap in terms of people who bring, people who get, people who contravene or abuse the children or adults. Of course, there is the criminal aspect that will come in, and therefore the law will take its course. So I don't necessarily see a big difference between the discipline aspect of it and the punishment aspect of it, other than one is for deterrent and the other being to just implore or to encourage. Yeah?
Thank you.
You're welcome.
Any other comments or questions? Especially at this time for Senator. Yes? And then your question. Oh, thank you very much.
Good afternoon, everybody. There's just one question for the Honorable. Yes, if we are going to consider your suggestions, your bill, and so on, the question that arises, if we expunge a record here in Grenada, what application does that have with the governments of other jurisdictions? A young man has his record expunged here. He still has to go to the U.S. Embassy to apply for a visa.
Yes.
And as far as I understand it, the U.S. government still has the right to tell him, we know that you were convicted of XYZ.
It's funny you ask that, because just this morning in court, or yesterday morning, I can't remember, somebody was saying that well, let me tell you the effect of it. The effect of it is that when you apply for a criminal record, you will have no record. So as far as we are concerned, that no record applies everywhere you go. So even if somebody somewhere says, well, I know you did something, they would still not be able to officially say he has a record. Now, whether or not some other person, for example, Grenada is a small society. So I commit a crime, and 5 years after, I get my record clean because the crime was such that I could. And I go for a job down in in Silver Sands, and I say, well, my name is Peter David. They say, where's your record? I give them no record. I mean, you had a record. I know you would break a place last month. No, that last 5 years ago, sorry. No, that employer has a discretion to hire you or not. So he can do that, and there's no illegality in doing that because you have no right to the job that he's infringing on. So if you're infringing on a right that you had, sure, you can take him up on that. So in that case, there's nothing you can do. Similarly, if you go to the U.S. Embassy, and unfortunately for you, the U.S. Embassy knows, then they can take it into account without even telling you. That's why they're denying you. But for legitimate purposes, for the record, you have no record anywhere. That applies anywhere you go in the world. That you as a person, because it attaches to you, you present a clean record, you can say, my record is clean. Now, we'll ask you if you ever commit a crime and you want to say that you did, then that's another matter. But Dr. Alexis.
You see, there is another step. There are a number of issues like this where I think small states like ours have to carry the matter further, in the sense that there is a need now for some kind of universal agreement as to what happens when local laws act like you're suggesting. So maybe Grenada might become the champion in that regard.
Well, I think in the case of the rehabilitation of offenders, you have no record. So another state will have to accept that as no record. For example, somebody comes from Jamaica to Grenada and they have a Rehabilitation of Offenders Act in Jamaica, and they come to Grenada and they ask them for their record and they say this is a clean record. It applies in Grenada too. So I think in that case, because the record attaches to you personally, so you are clean as far as we are concerned, therefore you should be treated as clean by everybody who comes into contact with you and wants an official record.
But, well, I could carry that on, but the only thing I want to sort of push a bit is that I think small states make these beautiful declarations and so on, but the bigger states can do, to put it bluntly, what they damn well like with our citizens. And there is a need for more collusion, cooperation, at the international level to push the whole restorative justice issue is raised as well, okay?
Absolutely correct, Bishop. So, but as you said, that is an issue that we need to address at another forum, maybe. Thanks.
Okay, we have some other questions. I just want us to recognize Senator David as the Facilitator. And thank you very much, Senator.
Let me just briefly introduce myself. I am K. Julian Gutu. I am currently the Marketing and Communications Officer of the National Training Agency, but I'm here in my personal capacity tonight. I'm also a part-time lecturer at TAMCC. One recently research presentations, and she presented on rehabilitation with the prisons in Grenada. And in going through her paper, she expressed that rehabilitation is voluntary. So the prisoners do not have to sign up to do any of the 5 programs that are available in the prison unless a judge says that they have to do counseling for anger management or such like. So I don't have the truth of that because I didn't do the research. But I am of the feeling that they should at least, once you go into prison for a crime, that you should at least do at least one mandatory rehabilitation program that's available at the prison. I'm not sure if rehabilitation program will make you a better person, change you around as a person so that you never commit another criminal act, but I do think it could be a step in the right direction for the criminals. So I don't know. That's just a comment, what that is like, if there's any truth to that prisoners voluntarily choose whether they want to be in a rehabilitation program and that they could be there 15 years and not be in a program. The other point that I wanted to make is on the question of the legalization of marijuana. I'm openly an advocate for legalization of marijuana for various reasons, which I won't go into here tonight. But I do think that if an individual is found with small quantity, I believe in Jamaica, they'd have, if you're found with a certain quantity under a certain amount, that you are free to carry it or have it in your possession. Only if you are found with a certain amount, which is in law, then they will arrest you. So I don't think somebody should have their whole life affected by, while I am not an advocate of the 1960s Woodstock, I don't know, I'm sure everybody knows what Woodstock is, kind of lifestyle where we're just everybody free-loving and smoking marijuana. I'm not for that. When I talk about legalizing marijuana, I'm talking about medical marijuana. So I do think that we shouldn't have our young people being affected through a little bit of use of marijuana, having records for that. Another point I wanted to make was on the issue of the child protection. I think that the deviant behavior, we definitely have to start in the home setting from very young, and that there's no more intervention needed by the child protection authority, if that is the agency to deal with it, or social services or social development. And I will give you a story that happened to me a few years ago. I was at my church one Saturday, and I heard a child screaming in agony. It was not a big child. I could tell that it was a toddler, like about 2 or 3 years old. So after I couldn't take it for a long time because my soul went into agony, I walked across to this person's home, complete stranger, knocked on the door and asked what was going on. Then I got into an argument with the mother of who was beating the child. She was breaking up whatever she was breaking up on, this very small child who couldn't be more than 3 years. And then I told her I was going to call the police. And then she said she was going to call the police because I had trespassed on her property. And indeed, the police did come and came over to the church and spoke to me because she made the report first before I could call the police. And then when he came over, he said, well, next time, don't go on the people's property, call the police. But I am saying that we need more people who can, you hear something going on wrong in your neighborhood, you hear children being abused, that we need to step in, we need to call maybe the authorities. And do you know, lo and behold, I found out afterwards that that family was under investigation by social services and that they were looking into that the child was indeed being abused over and over. So I have thought about that child over the years, and I hope that the child was placed in a better environment and so, but I don't think I did anything wrong, but yet I had the police called on me, and the police came to talk to me about the fact that I trespassed on somebody's home to stop an abusive situation. So I think, like, as a whole country, as a community, that we need to step in more and be involved in people. I'm not saying to be fast or to macro. I'm saying that if you notice something is wrong in a child's life, because we have situations, even for teachers in the schools, to be trained so that they can notice when a child's behavior is different so that they can pick up if there are abusive situations. Because continuous abusive situation is what leads to the deviant behavior, the children who will later commit crime and so on. So we need to nip it in the bud when they are small. Thank you.
Thank you. Any questions from the World Wide Web? We would welcome them, or comments. We would ask the providers to share those with us, and we will take maybe 2 more questions and or comments as it's getting a bit late.
We must become advocates against flogging. I am an advocate against flogging. Shireen Francis Hackett, attorney at law. I have a comment rather than a question. Yesterday afternoon, in fact, I had the privilege of visiting the prison. And I sat face to face with one of the prisoners currently serving his sentence. And he relayed to me his horrific experience of being flogged. And this flogging was only, he was sentenced as recently as last month. This 58-year-old man related to me that he was stripped of his clothing. He's a father, and he was stripped of his clothing. He told me that no medical examination whatsoever was conducted by any doctor in relation to him and his health or anything of that sort. And immediately on the same day that he was sentenced approximately 2 p.m., and by 2:30, 2:45, he was stripped and brutally flogged at the police station. It not only left him with physical scars, but it also left him with emotional wounds. And he said to me that he had no legal representation. And that is very sad, because there are a lot of prisoners, there are a lot of persons in our communities who cannot afford legal representation. And because they are poor, they are exposed. But this is a different topic. As I said, I would like to get some feedback from the head table as relates to that. I can go on, but I cannot forget the experience that this 58-year-old man would have relayed to me yesterday at the prisons. Thank you.
Yeah, so I too agree that we need to do away with flogging. In fact, I don't know how many people are aware, but as we speak, there is currently a constitutional challenge before the court, before the High Court, challenging the Section 70 of the Criminal Code, which sanctions flogging on the ground of its being discriminatory. Now, it's sort of legally technical, because I referred to the Pinda case earlier. Now, what that case says is the Privy Council accepted that flogging was cruel and inhumane and degrading. However, because it was saved by the Constitution itself, they felt that they were unable to touch it. But being saved as a punishment doesn't mean that it's saved from, that it's immune from challenge on any other ground. So it's actually being challenged on the ground that it's discriminatory, insofar as it applies to men only. And the submissions are currently being developed, and it would make a very interesting dispute in the court. What is surprising for me is that the government is in fact challenging it. So the government is putting up a fight to keep flogging. I thought that this would have been an excellent opportunity to say, you know what, this old, outdated, obsolete thing, let's just really do away with it. But surprisingly, the state is actually putting up a fight. So as I said, I really look forward to seeing what ultimately comes of the matter. I think either way, the decision would be one that improves our jurisprudence.
One of the advocates in court presently mounting this challenge on the flogging. Dr. Alexis.
Thank you very much. Yes, that is true. I'm one of the lawyers challenging flogging. In Jason's case, is there a prosecutorial discretion for not to prosecute, say, for example, a person having one joint? And what is the position with the magistrates? Do they say, well, approach the bench, one joint, you really want to go ahead? Well, maybe coming out of this exercise this evening, I'm not an expert, but perhaps we can send a thought about it, this question of prosecutorial discretion, and calling upon the magistrate to say, approach the bench. You really want to go ahead with this? One joint? Thank you.
Thank you very much, Dr. Alexis. That sounds very simple, but it is very legally profound, and it would mean that we would really change our criminal justice system by proceeding with such an approach. Any last comments or questions? Please. You'll introduce yourself?
Sure. Hi, good evening. Thank you for the panelists for your thought-provoking presentations. Nigel Maitland, publisher of Now Grenada. Most of the comments that we have had are in support of the suggestions made by all of the panelists here. The last comment that we had says, I'm an advocate against all flogging at home, in school, and as well as adults. I have two questions for myself in terms of clarification. One, in terms of the abolition of flogging. I am not in support of flogging either, but at the same time, our prison is overcrowded. I believe probably the rehabilitation center is even overcrowded or getting there. So if it is that flogging is abolished, what other form of punishment or however it is that you choose to put it would be available as opposed to incarceration, since our facilities are already overcrowded. That's question number one. The second question relates to Senator David's presentation. Unfortunately, he's not here, but maybe somebody else here may be able to assist. And that would have been in terms of expunging criminal records. So again, my question is it that someone would be eligible for their criminal record to be expunged once the prescribed time has elapsed? Or would there be some sort of determination or assessment as to whether that person has really been rehabilitated? Because somebody may have served their time, and the time after that may have been elapsed, and some persons may have been rehabilitated, and some other persons may have not. So my question is it an automatic expungement, or is some other further assessment done?
So in relation to the first question, under our laws currently, there are a number of alternatives that magistrates or judges can impose as punishments on persons. So there are community orders, whereby persons are made to work to do community sentences. Alternatively, a magistrate or a judge might order someone to do particular counseling programs. So for instance, a sentence might be suspended and the magistrate says to someone, well, I really should be sending you to jail, but I'm going to suspend the jail sentence pursuant to your doing a man-to-man counseling session, for instance. Let's say it's someone who was accused of beating their partner, and the magistrate can do that. So there's that discretion. But that discretion is even more amplified in the Juvenile Justice Act. So while, for instance, it's a discretion that exists, which magistrates can and sometimes do use in relation to general offenders, it is something that is actively encouraged under the Juvenile Justice Act, so to sort of keep vulnerable youths outside of the criminal mainstream, so to speak. So that's one thing. The community orders or the alternatives, community orders, suspended sentences, that sort of thing. But I think there's also a deeper question that we need to ask ourselves, because there's almost a suggestion in your question there that, well, flogging is a sort of easy fix. The jail overcrowded, just beat them and done the talk. But let's say had it been chopping off hands, at some point in time, we just have to establish a minimum standard of punishment that is applicable to human beings, that goes back to our understanding of what is the inherent dignity and worth of a human being. And I think that's ultimately the question that needs to be asked. Where we would find the answer to the conundrum. What was the second question again? Oh, all right, no problem. I'm not very familiar with what the bill says. I didn't peruse it in recent times. I would have overlooked it in its initial phases. And my understanding is that it's automatic in the sense that once you've not committed any other offenses within that period, you become entitled, so to speak. But it doesn't happen automatically. I still believe that there's a process you need to trigger to get the expungement done. And that is my understanding. I may be wrong. As I indicated, I haven't perused the act recently at all.
Okay, so it's coming on to 6:30. Unless any of the students or any one person is a student, anybody else? But especially a student, I'm willing to allow you to come forward. And also, just to say that I believe from what Senator David said, there is a time period that has to elapse before the person can apply to have their record expunged. Because I guess it assumes that if, let's say, 5 years or 10 years would have elapsed and you have no other conviction, or you have not tangled with the law again, that you are rehabilitated. That is why it's called the Rehabilitation of Offenders Act. So there's an onus on the person who's making the application to prove that they have not been continuously engaged in anything that is unlawful or had any other run-in with the law. If not, it would not happen, because due diligence would have to be done by the authorities when the application is made. So the police would be approached, the other agencies, and so on. So now we'll have our last question, is it, or comment? Anybody else who has a burning question? If not, this will be our last question or comment, and then we have some refreshments for you as we begin to wrap up.
Good night, everyone. I'm just making some comments on behalf of my my fellow classmates. My name is Darisha Henry. I am from Lamont St. George's. I am a second-year student at TAMCC. Okay, first is a question to Miss Jacqueline, or Miss Ogilvie. Sorry. What measures would you say are imposed to solve the problem of primary school students being like aggressive, or to prevent them from actually reaching to the stage that they actually have to be at a juvenile center? Are any measures taken to prevent that from happening?
I know certain primary schools have counselors. I don't know if there are other programs available to parents and teachers to train them how to deal with them. Some, as earlier Lady Trotman-Joseph said, that some schools were taught in conscious discipline. Now, conscious discipline, it's a change in our mindset and how we see our children. It impacts, our cultural views and so. And so for persons to implement it, in some areas, persons say they've done it and it works, they've used it in the home, and so because it's really intentionally, you're stepping back from the behavior and intentionally responding to it, right? Because instead of through anger and so as we do, and looking at other alternatives to responding to the behavior. And it takes some time. It will take some time for us to do that. So outside of those schools who've been trained in conscious discipline, I know some schools have also been trained in common sense parenting. Similar concepts. They're called different parenting programs, but they're similar concepts and so, but really understanding the root of the behavior for our children. And I quite understand for teachers as well. If you have a class of 30 children and you have maybe 2 or 3 misbehaving, and you preparing them from CPA and this sort of thing, and you may be burnt out and all this sort of thing, then you really don't have the time to try and get to the bottom of why this child is misbehaving or this child cannot focus in class and so, unfortunately for the child, right? So I believe that we do have to get better, and it doesn't, and I always say, and I'm glad we have 2 members of the clergy here, I always say it doesn't have to be government. Yes, it is our responsibility. We create the problem, so let us come up with a solution. And so this is really my soapbox here, because I really think there are enough professionals, there are enough wise people within different spheres of our society who can say, okay, I have an hour a day, I'll take a lunchtime, 1 hour a week to go and sit with a child to read. And sometimes a child is misbehaving in a classroom because they're frustrated because they cannot keep up. We have 15 and 16-year-olds in a center who are reading at the rate of a 5-year-old. And that's what it is. So they drop out. Intentionally, they drop out from school, they get involved in problems and so, because guess what? I'm not keeping up in class, miss moving on, and so. And that is one of the criminogenic needs of juveniles. Yeah, they're underachievers. And so it's recognizing that it's persons, it doesn't take a lot of time, a lot of money, will take more time, and we say, in my soapbox, we say we're a Christian organization, but we're not willing, and I say that even from a juvenile perspective, we're not willing to go out there and do what it takes. Likewise, we have juveniles, and this is a forum, that we need foster carers as well, because that child may just need a period of respite. The parent might need a respite, and so maybe a nice great aunt to come to, and it could be a foster carer. But then for the persons who come forward to be foster carers are not us here, you know. Is a little person who just like children and willing, they may not even have the space, but they're willing to make the space for to have somebody else's child. So I went off, but that's my soapbox there, right? That is the issue. We're not enough programs and so available to children after school programs to support. We leave it all up to the school or the government. When your church doors could open in the afternoon for children to come and have a safe place to read, and so and support them and before the parents come home from work. Thank you. I hope I've answered your question.
Yes, you have. Just a quick comment I wanted to make. I think that the approach to include the parents in the rehabilitation of these juveniles is actually a good move, because like basically mostly what we see here in Grenada is that while talking to parents, you realize that a lot of them don't have that good bringing up, or from like old traditions, that's what they learned, so that's what they instilled in their children, and they don't know, a lot of parents don't know how to connect with their child or how to sit and reason with them. You know, most parents have this idea, you know what, I'm older, so I know everything. You can't tell me anything. You know, not because you feel like you have a better education, you know more than me. I got that a lot from my mother going to school. And I had to learn from my counselor, you know what, trying to sit down and talk to her, find out what her childhood was like, probably might help me understand her more, and that actually did. Yeah, because like talking to her, she told me, you know what, growing up, she didn't really have anybody to talk to. She didn't feel like she could talk to anyone. And I was like, I always used to be like, you know what, that should be an excuse for you to treat your child that way or something like that. You know what, you need to get help. Try to connect, try to be there and that kind of stuff. So yeah.
I'm glad you made that point, because hurt people, right? And so my mama said, you didn't come with a manual, right? And if a parent, and we see that in the child protection system, we see that in juvenile justice system, that parents themselves have had traumatic backgrounds and that they've never gotten the support for. So of course, when a child is displaying these maladaptive behaviors, and if you have, as a parent, might have your own mental health issues, undiagnosed mental health issues, or including attachment issues, hello, you're not going to be able, with a sound mind, and so deal with your child's behavior in the right way. You might see them in court. They will come to court, right? But it's how they connect and deal with that, it's another thing. And so it is hard work for us. Not all parents are on board. Some parents, the parents who you see make excuses for their children's behavior, see a lady Anande watching her clock. The parents who make excuses for their children's behavior, that is a problem for us. So those are the ones who are hard to reach, right? It is, first of all, you have, that parent has to come to that point, and we can help them do that, but sometimes they have the block. They have to have some insight into why I parent the way I parent. Forget about the child's behavior, but my own strengths and weaknesses and how that impacts on my child. Mm.
Okay, yeah, that's something for Mr. John. Yeah. You would have mentioned that corporal punishment should be removed, right? Because it is used to dehumanize and is seen as cruel, etc. But one of my classmates made the point that, what about the extent to which you administer the flogging, that should be considered, because the individuals who commit the crime didn't consider how cruel they were to the individual they committed the crime to.
Yeah. The administer of flogging is something that is very, it's something that would be topical, of course, because as I was alluding to earlier, if I lash you one way, another person may not lash you the same way. So there's a disparity in terms of the meting out of the actual punishment, and therefore there would be, I guess, some cause for concern among all of us in terms of how do we go about administering the discipline towards the children in terms of punishment and so forth. Yeah? So that's a good idea. I didn't think about that before.
Yes.
Yeah.
All right,
Yes.
I think that's all. Thank you.
So let's give the entire class from TAMCC another round of applause because you represented them. Thank you very much. I think also coming out of this afternoon's and into evening's panel, we need to take a deeper look at flogging as it is dispensed in our court system or through our court system. I personally think it's barbaric, and I will be joining others to lobby for its removal from our statute books. And I know the bar likes to march for many things, but maybe this is one of the things that the bar should march for. I believe that we need to look perhaps at decriminalization, but in the context of how that will affect our young people and the psychosocial support that has to go into that. Jamaica is taking the lead on this, and of course there are lots of calls to ensure that those under 18, we don't criminalize them, but we urge them not to use drugs or substances of any sort, including alcohol. So we continue to support that. But we've heard the story of Jason, and there are many more Jasons. And because of that, I believe that together we have to know that we have to be sensitive to our young people, not to criminalize them, but to be with them, support them in every way. We've also looked at what is happening in our juvenile system and so on. And we've had our say, and I think we will continue to have our say, and especially those of you on the World Wide Web who are making your comments, we will take a look at those comments, and others will continue to comment, because these issues, we want to keep them alive. And as the Bar Association, we thank you for coming out. Even though our numbers are small, we know that through this social media audience that we've had very, very wide reach. We were told that we had over 800 people viewing us, and so that is wonderful. So without ado, I thank you all for coming out. We thank especially the church, diocese, and parish, not only for representing through the bishop being here, but for Father Andrew, who is also here, taking time out from their meetings to come up and be a part of these culture-shifting kinds of discussions, because we know that they have a major role, not only at the church level, but at the school level, in ensuring that we are speaking in the same language, that we're understanding the older to the younger, and really knowing what supports are needed, especially for our young people at this time. We thank you, and we look forward to seeing you at our next panel discussion as we continue to discuss the social issues that are impacting not only good governance, but can impact negatively or positively all of our lives here in Grenada.